Hello friends, welcome to Bankers Platform. Today we have come again with new set of questions. So please like this video and share this video with your friends who are preparing for JIB exam and subscribe to our channel. So today friends we have come with most expected questions for JIB and our subject is legal and regulatory aspects of banking. Please make notes of these important questions for your future reference and these most expected questions can be asked in coming JIB exam. So let's start with our first question. Our first question is DRT is headed by a recovery officer, registrar, presiding officer, banking ombudsman. So let's see what is the correct answer. Correct answer is C, presiding officer. DRT friends, as you know, debt recovery tribunal. So जो debt recovery tribunal है, that is headed by presiding officer and he is assisted by recovery officer and registrar. So let's see some of the points of presiding officer. So first is appointment. The presiding officer is appointed by central government. The central government may also authorize any other presiding officer or judicial member of a DRT other than DRT to discharge the functions of presiding officer of DRT. So qualification, if we will talk about qualification, a person who is or has been or qualified to be a district judge shall only be appointed as a presiding officer. And regarding term, the presiding officer shall hold office for a period of 5 years from the date of his appointment or attainment of 65 years, whichever is earlier. He or she is eligible for reappointment. So friends, ये कुछ facts थे related to presiding officer. So questions related to DRT is always asked in the exam. So if you prepare this DRT topic well, you will be definitely scoring 2 to 3 marks out of this. So let's move to next question. Question number 2. If any false information is provided to registrar of firms in connection with registration of a firm, the penalty is, our options are imprisonment up to 1 month or fine or both, imprisonment up to 2 months or fine or both, imprisonment up to 3 months or fine or both, imprisonment up to 6 months or fine or both. Let's see what is the correct answer. Correct answer is C, imprisonment up to 3 months, 3 महीने की जेल एंड फाइन और फाइन और बोथ, या तो 3 महीने की जेल होगी या फाइन होगा या दोनों. सो if anybody is providing false information to registrar of firms. Let's move to next question. Question number 3. Any person aggrieved by the order of recovery officer may appeal to dash within dash day from dash. So our options are President of DRT 30 days, receipt of copy of order of RO. President of DRT 45 days date of order of RO. RO is recovery officer. President of DRT 30 days date of order of RO. President of DRT 15 days receipt of copy of order of RO. So let's see what is the correct answer. Correct answer is A. President of DRT. अगर कोई भी पर्सन जो है रिकवरी ऑफिसर के ऑर्डर से ही इज नॉट सेटिस्फाइड, ही कैन अपील टू प्रेसिडेंट ऑफ DRT and within 30 days from receipt of copy of order of recovery officer. Let's move to next question. Question number 4. For the purpose of application of Bankers Book Evidence Act, the Bankers Book include A. Records kept as a backup, records available as disaster recovery, C. Records on microfilm, D. Records in a physical form. Our options are only D, only C and D, only A, C and D, D A to D all. So let's see what is the correct answer. Correct answer is D, A to D all. ये जितने भी हैं ए रिकॉर्ड्स कैप्ट एज ए बैकअप, जो भी रिकॉर्ड है बैंक का एज ए बैकअप, और रिकॉर्ड जो अवेलेबल है एज ए डिजास्टर रिकवरी, रिकॉर्ड्स ऑन माइक्रोफिल्म्स एंड रिकॉर्ड्स इन फिजिकल फॉर्म, ये सारा जो डाटा है दैट इज coming under Bankers Book Evidence Act. So let's move to question number 5. Which of the following is correct in context of Consumer Protection Act? So our options are A. Complaint can be filed by consumer himself as on his behalf. No consumer association can file the complaint. B. Retailer who buy goods to sell to other consumers can file the complaint. The consumer courts are quasi-judicial in nature. Consumer Protection Act has been enacted to protect the manufacturers and service providers from the consumer. So in this you have to give the answer which of the following is correct. So let's see what is the correct answer. Correct answer is C. The consumer courts are quasi judicial in nature. This is correct and rest are incorrect statements. Let's move to question number 6. Banking companies are not permitted to give dividend until all dash are written off. Our options are capitalized expenses, bad debts, dividend, none of the given options. So let's see what is the correct answer. Correct answer is A. Capitalized expenses. कोई भी कंपनी है बैंकिंग वो तभी अपना डिविडेंड देगी जब तक वो अपने सारे कैपिटलाइज एक्सपेंसेस को रिटर्न ऑफ ना कर दे. लेट्स मूव टू क्वेश्चन नंबर 7. Dash involves take Dash involves promotion of corporate fairness, transparency, and accountability in the interest of all stakeholders. Our options are risk management, corporate strategies, corporate governance. So let's see what is the correct answer. Correct answer is D, corporate governance. तो corporate governance का मतलब है promotion of corporate fairness, transparency, and accountability in the interest of all stakeholders. So let's move to question number 8. A contract is valid if the consideration is lawful when, at the desire of the promiser, the promise A has done or abstained from doing, B does or abstained from doing, C promises to do or abstains from doing something. Which of these is correct? A to C all, A and B only, B and C only, C and A only. Let's see what is the correct answer. Correct answer is A to C all. A to C जितनी भी चीजें हैं, this is a part of a contract is valid for the validation of the contract. Let's move to question number 9. In a mortgage suit, the preliminary decree becomes the final decree. So when it becomes final decree, our options are when the request is made by the bank as a creditor, when the borrower fails to pay the decree amount, when the court takes a decision on the basis of its discretion, when the request comes from the bank and the borrower. So let's see what is the correct answer. Correct answer is B, when the borrower fails to pay the decree amount. कोई भी मॉर्गेज का जो सूट है उसमें जो प्रिलिमिनरी डिक्री है वो फाइनल हो जाएगी अगर जो बोरोअर है वो डिक्री का जो अमाउंट है वो ना दे पाए. लेट्स मूव टू नेक्स्ट क्वेश्चन. क्वेश्चन नंबर 10. XYZ were allowed certain credit facility on the guarantee of G. Later on, the account was got secured by equitable mortgage of the property, but for certain reasons, the bank released the equitable mortgage when the account became difficult of recovery and the money was demanded from G. Also, he took the plea that he stands discharged to the extent the value of mortgage which has been released by the bank. So, in this case, which is the correct statement? Guarantee is not discharged as the mortgage was taken subsequent to the date of guarantee. B. Guarantor is not discharged as he is liable as long as borrower is liable. C. Guarantor is discharged to the extent of the value of equitable mortgage as bank has put the guarantor to loss. D. Guarantor is discharged since value of security in the account has come down. Let's see what is the correct answer. Correct answer is A. Guarantor is not discharged as the mortgage was taken subsequent to the date of guarantee. So this will be the correct statement in this question. Let's move to question number 11. In a contract of bailment, if the bailee does something inconsistent to the contract, the bailer can. So we have to find which is not correct. Demand the damages suffered, contract become voidable at the option of the bailer. demand compensation for any damage, none of the above. Let's see which is incorrect statement. So none of the above is incorrect. So these all things a bailor can do. He can demand the damages suffered. अगर किसी भी bailment के contact में bailey does something inconsistent to the contact, तो जो bailor है वो डैम he can demand, bailor जो है वो demand कर सकता है damages के लिए, और जो contract है वो वाइड become voidable at the option of bailor. वो bailor के ऊपर है कि वो contract को कंटिन्यू करेगा या उसे वाइड कर देगा. एंड डिमांड कंपनसेशन, वो कंपनसेशन के लिए भी डिमांड कर सकता है जो भी डैमेज हो. लेट्स मूव टू नेक्स्ट क्वेश्चन. क्वेश्चन नंबर 12. फॉर एक्शंस ऑफ ए पार्टनर इन अ लिमिटेड लाइबिलिटी पार्टनरशिप, which is correct? All the partners become automatically liable. The LLP does become liable. Other partners do not becomes liable except in special cases. None of the given option is correct. Let's see what is the correct answer. Correct answer is C. Other partners do not become liable. जो लिमिटेड लाइबिलिटी पार्टनरशिप है उसमें हर पार्टनर की एक लिमिटेड लाइबिलिटी होती है. एंड फॉर द एक्शन ऑफ पार्टनर अदर पार्टनर्स डू नॉट बिकम लायबल एक्सेप्ट इन स्पेशल केसेस. कुछ स्पेशल केसेस में ही वो लायबल हो सकते हैं, बट इन अदर केसेस इन जनरली दे आर नॉट लायबल फॉर द एक्शंस ऑफ अदर पार्टनर. लेट्स मूव टू क्वेश्चन नंबर 13. Which of the following right is not available to unpaid seller where the property has passes on the buyer? So our options are: a lien on goods for price while he is in possession of the goods. In case of insolvency of the buyer, a right of stopping the goods in transit after he has parted with the possession of them, a right of resale, none of the above. So let's see what is not available to unpaid seller. So the correct answer is none of the above. None of the above. Let's move to question number 14. Provisions relating to guarantees are given in Indian Contract Act 1872, Transfer of Property Act 1882, Banking Regulation Act 1949, Reserve Bank of India Act 1934. Let's see द करेक्ट आंसर. करेक्ट आंसर इज ए, इंडियन कॉन्ट्रैक्ट एक्ट. जितनी भी चीजें हैं गारंटी से रिलेटेड, लाइक वी आर मेकिंग बैंक गारंटी एंड एलसी एंड ऑल दैट थिंग्स, सो these all things are coming under the provision of Indian Contract Act 1872. Let's move to question number 15. A stipulation collateral to the main purpose of a contract under the Sale of Goods Act is called a condition, a warranty, a guarantee, an undertaking. So let's see what is the correct answer. Correct answer is B, a warranty. Let's see question number 16. What is the minimum and maximum number of partners in a limited liability partnership? So our options are minimum 2, maximum no limit, minimum 2 and maximum 50, minimum 2 and maximum 20, minimum 2 and maximum 10. So let's see what is the correct answer. Correct answer is A, minimum 2 and maximum no limit. So question number 17. Which among the following is a necessary condition for declaring it a government company under the provision of Companies Act 1956? So our options are: it should be fully owned by the central government, it should be fully owned by the central and state government, at least 50% of the paid up capital should be owned by the government, at least 51% of the paid up capital should be owned by the government. Let's see what is the correct answer. Correct answer is D. At least 51% of the paid up capital should be owned by the government. As we all know, जिस भी कंपनी में गवर्नमेंट का 51% का स्टेक है, दैट इज कॉल्ड अ गवर्नमेंट कंपनी. So let's move to question number 18. In a public limited company, maximum and minimum number of shareholders is 50 and 10, no limit and 7, 100 and 2, any number at the discretion of the company. Let's see what is the correct answer. Correct answer is B, no limit. There is no limit on the maximum number of shareholders in a public limited company, but minimum 7 should be there. So friends, many times these questions are asked: what is the minimum and maximum numbers of directors in a public limited company, private limited company? So you should go through these things so that you can secure your marks in the exam. So let's see some of the important points of this difference between private limited company and public limited company, which are asked in the exam. So here we can see in private limited, it is privately held company by close group of friends and relatives. So in private limited company, the it is held shareholders are relatives and friends. But in public limited company, it is publicly held company, which means anybody can become a shareholder. कोई भी shareholder बन सकता है public limited company में. But in private limited company, there is you can say close group of friends and relative. Like nobody will make some anybody part shareholder in their company. They will always prefer their friends and relatives to be the part of the company. So for incorporation minimum two, minimum we need two. So minimum two shareholders are required. But if we see in public limited company, so for incorporation minimum seven shareholders are required. So private में दो चाहिए minimum and public में seven. And if you'll see, there can be maximum 200 shareholders only in private limited. Maximum 200 shareholders can be there. But in public limited, there are no maximum limit of shareholders. There can be and number of shareholders. So there must be at least two director. कम से कम दो डायरेक्टर होने चाहिए प्राइवेट लिमिटेड कंपनी में. बट एटलीस्ट थ्री डायरेक्टर्स आर रिक्वायर्ड इन पब्लिक लिमिटेड कंपनी में थ्री डायरेक्टर्स रिक्वायर्ड हैं. एंड प्राइवेट लिमिटेड कंपनी हैज लेस कंप्लायंस as compared to the public limited company, where more compliances are required, because you can see that they have unlimited shareholders, many shareholders are there, so more compliances are required. And shares are not transferred easily. जो प्राइवेट लिमिटेड कंपनी के शेयर्स हैं वो इजीली ट्रांसफर नहीं होते हैं, बट द शेयर्स ऑफ द public limited company can be transferred easily. Like you can see the companies which are listed in the share market, they all are public limited company. So you can buy, you can sell the share very easily. But in private limited company, it is not possible, because they are also transferring the share, but they will not transfer to anyone. They will go for the close group, close group of friends and relative. So these are some of the main points of this public and private limited company. So let's move to next question. Question number 19. A company has been sanctioned enhanced credit limited by its bank for modification of change with the registrar of the companies. Which among the following forms are to be used? Our options are Form 8 and 10, Form 8 and 17, Form 8, Form 10 and 17. So let's see what is the correct answer. Correct answer is C, Form 8. So अगर कोई भी कंपनी है उसकी हमने सैंक्शन लिमिट में इन्हांसमेंट की है, so in that case, for the modification in the ROC, you need to fill the form 8. Let's move to question number 20. The copy of memorandum of association and article of association of a company is kept with office of ROC and can be inspected by any person, due to which it is known as doctrine of indoor management, ultravires, doctrine of constructive notice, doctrine of outdoor management. So let's see what is the correct answer. Correct answer is C, doctrine of constructive notice. Let's move to next question. Question number 21. A dash LC, a dash letter of credit is a specific type of letter of credit in which a buyer extends an unsecured loan to a seller. So our options are: it is green clause LC, it is green clause LC, B revocable LC, C red clause LC, D irrevocable LC. So let's see what is the correct answer. Correct answer is C, रेड क्लॉज एलसी। रेड क्लॉज एलसी वो एलसी होती है फ्रेंड्स जिसमें जो बायर है वो एक्सटेंड करता है अनसिक्योर लोन टू ए सेलर। सो लेट्स मूव टू क्वेश्चन नंबर 22। many times friends questions are asked from the LC part also, so you should go through this. You will be definitely getting 1 or 2 mark question from LC section, letter of credit. So, question number 22. As per Sale of Goods Act, the seller of goods is deemed to be unpaid seller if he does not pay the interest, price, penalty, transit charges. So, let's see what is the correct answer. Correct answer is B, price. If price is not paid to the seller, so he will be called unpaid seller. Let's move to question number 22. The IBC has proposed that the DRT shall oversee the process of insolvency of individuals, partnership firm and individuals, partnership firm, company. So let's see what is the correct answer. Correct answer is B, partnership firm and individuals. जो पार्टनरशिप एंड फर्म्स पार्टनरशिप फर्म एंड इंडिविजुअल्स है उनके जो इंसॉल्वेंसी के केसेस हैं दैट विल बी taken by DRT. Let's move to question number 24. Who cannot become partner in a firm as per Supreme Court judgment? Our options are individuals, HUF, company, none of the above. So let's see what is the correct answer. Correct answer is B, HUF. जो HUF है वो किसी भी पार्टनरशिप फॉर्म में पार्टनर नहीं बन सकते हैं। लेट्स मूव टू क्वेश्चन नंबर 25, and this is the last question of the day. Which of the following mortgage does not require registration with registrar of assurance? Our options are English mortgage, equitable mortgage, mortgage by conditional sale, none of the above. Let's see what is the correct answer. Correct answer is B, equitable mortgage. So equitable mortgage is very common in our banks और हम हर जगह equitable mortgage को ही preference देते हैं because it does not require मच, वी ओनली नीड टू टेक द टाइटल डीड। हम सिर्फ टाइटल डीड जो है प्रॉपर्टी की वो कस्टमर से लेते हैं एंड देन वी क्रिएट द इक्विटेबल मॉर्गेज इन अवर बुक। So this is very common type of mortgage and it also does not require any witness. So this is mostly used in our banks. So friends, many time questions are also asked from the mortgage section. 1 mark is definitely from mortgage section. So you should prepare this topic of mortgage also very clearly. So this is a set of 25 questions. I hope so friends you are benefited from these questions, and thank you friends. Thanks for watching. So you can also visit to our previous videos so that you can have a revision of the topics and the questions MCQs. So friends, please like this video if you're benefited from this video, and share this video with your friends who are preparing for jaiib exam, and subscribe to our channel if you have not subscribed, and also press the bell icon so that you can get the latest notification of our channel. Thank you friends. Have a nice day.